Hello everyone, ladies and gentlemen, good morning, good afternoon, or good evening, wherever you are. It's 8:52 a.m. GMT. We are ready to start the 6th Oxford Arbitration Day. My name is André Luís Monteiro. I'm a former junior academic visitor at the Commercial Law Center, Harris Manchester College, University of Oxford, and one of the organizers of this event, alongside Dr. Kristin van Zwieten, the director of the Commercial Law Center, and my colleagues Ana Carolina Dallagnol, Felipe Esperandil, and João Ilhão Moreira. This year is the second time the event will be held online. I don't need to explain the reason for that, everyone knows, but hopefully this year will be the last, and we will be back in person next year. Looking at the positives, the advantage of holding the event online is that we can gather people from all over the world who maybe would not be able to come along to Oxford. So we do appreciate our speakers across different time zones who accepted our invitation and need to log in very early or stay awake until late night. For example, this year we have speakers from Mexico who are 6 hours behind the UK, and speakers from Hong Kong who are 8 hours ahead. So thank you for the flexibility. This year the event is comprised of 4 panels and 1 interview. Firstly, we are going to discuss cybersecurity and international arbitration. The arbitration community is familiar with recent cases in which lawyers, parties, arbitrators, arbitral institutions were attacked by hackers, exposing confidential information, jeopardizing legal strategies, putting the arbitral world at risk. The question is very simple here. What are we going to do to protect arbitration and its players? Secondly, we'll have a great opportunity to hear from a prestigious group of in-house counsel on their views about arbitration. It's the view from the client, and it's absolutely essential for arbitration. In this second panel, we'll give the floor to highlight not only the advantage of arbitration, but also its potential disadvantages. The third panel deals with arbitration in emerging markets, and we have speakers from Africa, Asia, and Latin America. International arbitration is supposed to be international, and the development of arbitration in these jurisdictions is closely related to the legitimacy of the method. Our last panel will explore arbitration, energy, and climate change, a hot topic nowadays. In particular because countries from all parts of the world have been implementing policies to boost their economies and their energy sector, but at the same time trying to comply with international compromise related to climate change and respect investment. It's not an easy task. And what's the role of arbitration in this scenario? Our speakers will help us with this question. For our grand finale, Lucy is reviewed by Pedro Maciel. Lucy is the current president of the International Council for Commercial Arbitration, and she will tell us some inspiring stories from her career and also give her opinion on complex issues in arbitration. I don't want to finish this welcome address without saying a huge thank you to our sponsors, CAM CCBC, Veirano Advogados, Souza, Sescom Barrier Advogados, Lefosse Advogados, Tosin advogados, Baraldi Mariani, Demarest, Mannheimer Paris Lira advogados, and Souto Correia advogados. Special thanks as well to Arbitragem, led by Loro Parente, who are broadcasting the event, and to his team as well. I will finish my part by wishing and inviting Dr. Kristin van Zwieten to officially open this event.
Thank you very much, André. Hello, everyone. I'm Kristin van Zwieten from the Law Faculty at the University of Oxford and the Director of the Commercial Law Centre at Harris Manchester College. We at the Commercial Law Centre have been very happy and feel very lucky to have had what is now a long association with André and with this excellent annual event. André is, as you know, a partner at Quinn Emanuel Urquhart and Sullivan and a very senior arbitration practitioner and published author. And I think he must soon stop calling himself a once junior academic visitor at the Commercial Law Centre because it sounds increasingly anomalous to my ears. But we were very lucky to have him as a visitor to the centre. And I believe that it was through this visit that the idea for this outstanding annual event was conceived and nurtured. Of course, today's proceedings are the result of work not only by him, but also by Anna Carolina and Felipe and Joao. And I'm also, like André, very thankful to the sponsors of this event who have made it possible. And I'd like to echo his thanks to all of you who have sponsored this event. So congratulations to all of the organisers and to the sponsors. I think the programme looks really excellent. At the Commercial Law Centre, we're interested in supporting scholarly exchange about important questions of commercial law and practice between academics and practitioners and judges. We're interested in supporting research into jurisdictions that have historically been neglected by academics who work in aspects of commercial law, particularly in emerging markets. And we're interested in research into practice and procedure as much as into substantive law, with a view to understanding in the real world how commercial law impacts on transacting and whether those effects are socially desirable or not. And I think all of these elements are really clearly on display in today's excellent program. And I'm very much looking forward to listening and learning from the proceedings. So without more, right on time, I am very happy to officially open today's event, to again add my congratulations to the organisers. I'm looking forward very much to the first panel, which will be chaired by Aline Dias from FLH on cybersecurity. So over to you, Aline, and looking forward to the event. Congratulations again.
Hello, everyone. Thank you, Kristin and André, for the introduction. Good morning, good afternoon, good evening in multiple time zones. It's such a pleasure to be here today, starting the Oxford Arbitration Day with this panel of cybersecurity and international arbitration. Thank you so much, Ana Dallagnol, and André Monteiro, Felipe Esperandil, João Moreira for the invitation and for the terrific organization of the event together with the arbitration channel. Thank you. As Kristin has mentioned, I'm Aline Dias, a Brazilian arbitration attorney and also a professor of courses dedicated to international arbitration, dispute resolution in general, and the use of technology. Today, I feel very, very lucky to be your chair in this first panel. Please be aware that we do plan to have a few minutes dedicated to questions from the audience. So if you want to ask something, just type your question in the box that you may see in the screen, and we will do our best to address them during the course of the panel, okay? So today for this first panel, our carefully selected panelists are Brendan Malone, Lee Bacon, and Sarah Grimmer. Brendan, as you all may know, is a barrister with Quadrant Chambers. He has been appointed to deal with arbitrations under a variety of ad hoc institutional rules, including those of ICDR and LCIA. He's the chairman of the Scottish Arbitration Centre. And for the purpose of today's event, it's important to mention that he has also chaired the working group on cybersecurity international arbitration of the International Council for Commercial Arbitration, the New York City Bar, and the CPR. Next, we will have Lee Bacon, a partner at Clyde & Co in London, with obviously very extensive experience with international arbitration and dispute resolution as well. Lee is also a well-recognized leader in the field of smart contracts, blockchain, and technology. It's very good to have you all today. And finally, we will have Sarah Grimmer. She is the Secretary General of the Hong Kong International Arbitration Centre, responsible for international dispute resolution services and operations from Hong Kong, Seoul, and Shanghai. In the past, Sarah has also worked at the Permanent Court of Arbitration, The Hague, the PCA, and at the International Court of Arbitration in Paris. Thank you all for being here today. So without further ado, let's move to the discussions that we have planned for today. And I will start with Brendan. Brendan, is that okay for you?
Yes, of course.
Okay. So, Brendan, please feel free to make any introductions you want to, but I will first ask you a question that I'm sure that everyone wants to know a little bit of your experience in chairing the working group on cybersecurity. What were the main concerns that you had? How did you deal with them?
Sure. Well, this originally arose out of the ICCA Congress in Sydney. I was chairing the panel on, or one of the panels on technology, was looking at the potential negative impacts of advances in technology, and cybersecurity concerns were obviously an aspect of that. So we're preparing for the Congress, and there'd been some concerns about cyber attacks. There was one paper in particular, quite a seminal paper by Mark Morrell and Steph Cohen, cybersecurity arbitrators call to arms, probably paraphrasing, but it was a very important article that got people thinking. And I thought it'd be useful to have a protocol for the arbitration community about cybersecurity, because there seemed to be a general lack of understanding of the issue. So I put it to the ICCA governing board. So in terms of the concerns and how we dealt with them, a big concern initially was, well, do we need more soft law? Do we not have enough soft law already? Do we want to be creating further standards that tribunals have to think about and parties have to think about in an arbitration? But ultimately the view was, yes, it would be useful, but there was when we set up the working group, it was, well, please try not to be too prescriptive. Please try not to create liabilities, etc. So that was a concern. I would say as we went along and the issue became more publicized and we're consulting, that feedback went from keep it general to please tell us exactly what we need to do. Just tell us what we need to do. We want to comply with it. And so that was a difficult issue, is where do you draw the line? You certainly don't want to create liability within the protocol. The protocol is very much a voluntary document that people can follow or not as they desire, but we do recommend parties incorporate it in their arbitrations. So we then had to think about, well, where do you put the ultimate responsibility for cybersecurity decisions? And the view we arrived at there was it ought to be the tribunal that has the final say, as the guardians of the process, the guardians of the integrity of the process. Obviously the tribunal should be speaking with the parties. If the parties can agree a position in advance, that's great. But where there is a difference of opinion between parties on how sensitive the subject matter is, for example, or what the need for cybersecurity is in a particular case, ultimately we say ought to be for the tribunal to decide that. And finally, I suppose an issue we had to think about was getting a wording that would stand the test of time, because of course technology is always moving. But I think that we're content that the wording we have there that we published in 2020, we're always looking at it to see if there's any need for change. But I think the wording is sufficiently flexible that certainly at the moment it's still good and still applies to the current situation in technology. Well, all kinds of fun things coming down the line, like quantum computing and artificial intelligence enhancements and what have you, that might will have a big impact on cybersecurity, actually, because a quantum computer will just pick your cybersecurity apart, but then you'll need to come up with new cybersecurity measures. So yeah, but at the moment we think we've got that right. So I'd say those were the main issues we had to think about.
In your opinion, what are the most effective tools, rules, guidelines that were included in the protocol?
Well, there are quite a few tools. I don't know if everyone's had a chance to look at the protocol. I would encourage them to do so. It's available on the ICCA website under the project section, and there's really a lot of useful information in it. If you look at Schedule B, for example, it provides tools to assess the risk in a given arbitration. The approach of the protocol is very much you should adopt cybersecurity measures which are appropriate for the particular arbitration. Some arbitrations are going to be very low risk. There's going to be very little interest in it because it's low value, or all of the information's in the public domain and what have you. Some arbitrations, on the other hand, are extremely sensitive because they may impact on the viability of a company. They might be very sensitive intellectual property involved, technological assets. So any amount of reasons that something might be very sensitive. And the Schedule B talks about the factors you need to consider when making that call. So it looks at the nature of the information, the risks relating to the subject matter itself, any risk factors relating to the particular arbitration. So for example, is one of the parties very much in the public eye, a controversial figure, and also what would the consequences of a breach be? So for some arbitrations, the consequences would be very small. For some arbitrations, they could be devastating. So it's making all of these assessments, and in that context, then deciding, well, what kind of cybersecurity measures do we want to put in place? And as I say, it's appropriate cybersecurity measures is the guide that we have in place. Obviously, it would be possible to spend thousands, millions of pounds trying to make your arbitration completely cyber secure. That will be beyond many parties, and we're not saying that the counsel of perfection, because ultimately, if a sophisticated state actor wants to hack your information, they're probably going to be able to do it. But I have heard of one arbitration at least where everything was so sensitive, they actually just came offline altogether and sort of went backwards in technology and used offline computers and typewriters, and I'm not quite in a lead-lined room, but certainly in a very secure environment, so that there was no prospect of that information getting out. So yeah, I think that's an effective tool. We also have some style. We have sample information security measures, for example. So if you're thinking, well, what should we do to help protect our info? Then there are examples of things you can do in respect of asset management, asset controls, access controls rather, and encryption, and giving some real pointers there, concrete pointers. And then we also have some style wording for orders and what have you. So I think that's very useful too.
Yeah, very nice. And Brandon, just to be here in the topic of the protocol, what what are you seeing in terms of the parties' willingness to engage with cybersecurity issues in arbitration before and after the pandemic hit? Has there been any changes?
Yeah, I think there has been a change. You know, when we first had the consultation and we had the draft of the protocol out, and then when even when it was published, which was well, originally the final version published for consultation, I would have arbitrations, and you'd raise this with parties, and they weren't particularly interested. They said, "Well, it's fine, we'll just carry on." But what we've seen now that everything has moved online, as it did for a good period, people are starting to meet up again now. But certainly for a good period there, absolutely everything was online, and I think that made people really think about, are we secure? And so I think you certainly did see an increased willingness to engage with these issues. The institutions are taking this very seriously now, and in some rules you see specific reference to cybersecurity measures, and I think people are really thinking about their professional liability to ensure client confidentiality, their ethical responsibilities, legal responsibilities. If you look at things like the GDPR and data protection legislation around the world, there are duties to maintain adequate cybersecurity. So I think all of this has enhanced everyone's understanding of their duties and responsibilities. So it's much more at the forefront of people's minds with the pandemic, certainly.
Good. And I don't know if you can do that, but can you share with us any, I don't know, high-profile cyber attacks in the legal sphere that happened since the launch of the protocol?
Since the launch of the protocol, I mean, there have been, for example, there have been a number of attacks on firms and what have you. I suppose an interesting one or two, there were attacks on barristers' chambers in London, and ransomware attacks, as I understand it. And what came out of that, very interesting, they took an injunction against the hackers. Now, of course, they didn't know who the hackers were. Hackers tend not to tell you who they are. That's part of their charm. But they took out an injunction against the hackers using any of the information they had obtained. So it was an injunction against persons unknown. Now, how effective is that going to be? I don't know. But the court was willing to grant it. So the consequence, obviously, is if they find out who the hacker is, and they find out that the hacker has used that information, they'll be in contempt of court, liable to, fines, imprisonment, whatever. Will that be a deterrent to a hacker in that particular case or in the future? Remains to be seen. But I thought it was very interesting development there.
Yeah, great. And any of these attacks or other attacks that you saw, they were able to impact live hearings? How did they impact arbitration proceedings in general?
I'm not aware of any attacks during an actual hearing. That'd be interesting to see. But I do know about a case, a Brazilian case, actually, the JNF Investimentos case, which was quite well publicized. And there you had essentially allegations that one party had hacked another. And they claim to have provided proof of this to the Brazilian police. And the court in Brazil was persuaded to stay a part award to investigate what had happened, because there were allegations, obviously, that this information had been used to influence the arbitration. So, that's very interesting for a number of reasons. Certainly in the courts in various jurisdictions in Scotland, where I'm based, and in some other jurisdictions, that even if you steal data, if you get it by illegal means, it's still admissible. And it's then just a question of weight. How much weight do you attach to that evidence? But in this case, the argument was that the evidence was tainted, and that destroyed the whole process. Now, as I understand it, that case is in sort of limbo meantime, because one of the tribunal has resigned for different reasons, alleged bias reasons or apparent bias reasons. So we'll see what eventually happens with that case. But it's very interesting to see an actual cybersecurity attack having an impact on a live case, as you say. So we'll see what happens there.
Yeah, that's a very, very famous case in Brazil.
Yes, imagine.
Yeah. And Brandon, do you see an increasing number of arbitrations dealing with cybersecurity breaches today?
I haven't personally dealt with cases dealing with cybersecurity breaches, but I know that some colleagues have been. So yeah, I think it is increasing. I know that the CPR Institute, for example, is one of our partners in the protocol. They have a panel who have particular expertise in that area, and they are getting work. And I know that the Silicon Valley Mediation Arbitration Center, they have some specialists as well, and they are seeing cases along those lines. It's something all of us may have to deal with at some point, because if you have an arbitration and you have a protocol between the parties on the standards that are to be maintained, and then there's a failure to comply with those standards, how do you deal with it? So do you go off and have a separate arbitration? Do you deal with it within the existing arbitration process? I think for the most part, you would probably deal with it within the arbitration process. But of course, if the case is already concluded, and there's an award, and then you find out that there has been a breach which may have impacted upon it, and that's sort of in the nature of cybersecurity attacks, because they don't tell you you've been hacked at the time. It's only you may never find out that you've been hacked. You may just suspect it, or you may find out days or months or years later that someone has data that was meant to be confidential. And in that sort of situation, if you were able to work back and discover that that attack had influenced the outcome of an arbitration, perhaps some time ago, how do you then deal with that? So these are all fascinating questions, but I haven't had to deal with them personally yet.
Yeah. So I would like to really encourage the audience to write the questions in the box that we have here on the screen. And Brenda, I have one more question. What are I don't know if you had that in mind, but I believe you did. What were the most common attacks that you all considered when preparing the protocol?
Well, I mean, we have we outline some of the main types of attack. I mean, arbitration isn't especially vulnerable to cyber attack compared with other dispute processes, but there are a number of factors you've got to think about. International arbitrations in particular are often very high value, and the process, depending which process it is, it may be confidential, which helps because people then, unlike a court action, people don't know what's happening, so it's more difficult to target. But if they do know what's happening, they may know it's very high value, and that may then influence people to try and get access to information. So the attacks we would be concerned about, certainly with a large-scale arbitration, there may be many people involved, and the more people you have involved, the more of their own devices they'll be carrying about, phones, USB sticks perhaps, the more email addresses are there to be attacked with phishing attacks. And I don't know about you, but I probably get 10 of these a day, people trying to get me to click on some mischievous link, and those are the ones that just get through my spam filter, you know. So I think the phishing, the ransomware attack is a real one. But straightforward hacks is, straightforward hacking, accessing someone's system by overcoming their their security is a real concern, because any arbitration at all, no matter how or how unconcerned people are about cybersecurity, there are stages in any arbitration and aspects of every arbitration which are confidential. So communications between client and advisor, for example, always confidential, always sensitive, because if the other side gains access to that, they gain an advantage. The deliberations between the tribunal, for example, at the end, if you're in a big case with a lot of money involved, and the tribunal is deliberating and passing a draft award backwards and forwards, and you gain early access to the result before it's published, then that's insider information. So you could take that information, and if you know that a company is going to go down for a $2 billion award, then that's going to impact on that company, and that's information you could use to play the markets. If you know that a certain state is going to lose a massive commodities arbitration, and you get that information early, you may be able to play the currency markets. It may affect their overall economy. So there's all kinds of manner of mischief that can be created in an arbitration if you gain that information. So I think straightforward hacking is a concern. Email, we've got to remember, is not a secure system of communication. But so I think those would be the main concerns. But we set out a great deal of information about the types of attack within the protocols. So again, I would commend it to people to read in detail.
Yeah, very good. We have a question here. It's actually a very simple one. It's the name of the famous case of cyber attack, the Brazilian one. I believe it's the Brazilian one, right? Yeah.
Yeah, it's one of the parties was JF Investimentos.
Yeah, I believe it's JNF Participações and CA Investimentos. Is that it?
Yeah.
Yeah, it's JNF against CA.
Yeah. CA Investment Brazil. Yeah.
And the following question that we have here is, can a party apply to set aside an award based on the fact that the arbitration was compromised on cybersecurity issues and seek an annulment of the award in exceed cases?
I think that would be very fact specific. We'd have to know what had happened, what the type of attack was, what had been compromised, and whether it had a direct effect on the award. I mean, I think it's possible to imagine circumstances in which that has happened. But again, okay, so if you say there's been a compromise in cybersecurity, that can mean any number of things. Has one party had access to the other party's confidential communications with their agent? Obviously, that's given them an advantage, but has it ultimately affected the tribunal? They may have obtained evidence by hacking, which they then lodge. That then becomes a question of relevance, a question of weight. Would the tribunal have treated it differently? But, you know, if it's something like if a party has accessed an arbitrator's computer and obtained damaging information that they've then used to blackmail or extort the particular tribunal member, then you can see that's the kind of thing that would vitiate an award. That's an extreme example, but it's possible to think of circumstances where a cybersecurity attack could void the whole process.
Yeah. I believe that in case that they jeopardize the process, in case they affect the method of appointing the arbitral tribunal, and so on, right? So, Brandon, thank you so much. Unless we have any other questions from the audience, I believe that we can now proceed with Lee Bacon. Hi, Lee. May I proceed with you?
Of course.
So, hi, thank you so much for joining us today. Good morning. I'll start with the questions, but feel free to add any other comments you may have, including comments on the topics that were very well exposed by Brendan. So, Lee, could you start by telling us a little bit about your experience with the use of arbitration clause for digital assets and centralized networks?
Yeah, very happy to. So good morning, everyone. Very, very happy to be here. Listen with interest to what Brandon was saying, and absolutely endorse it in terms of that's the sort of thing that we're seeing in practice. It's an evolving landscape, isn't it? My particular interest and focus is in the world of distributed ledger technologies, so blockchain and related technologies, and then the digital assets that sit on top of those, and by which I won't go into too much detail, because once I start, I'll go on for 2 hours, and nobody really wants that. But looking at all sorts of digital assets, whether that's cryptocurrency, NFTs, other tokens, and the use of smart contracts. And I think I have to say, smart contracts is a slightly loose term, but it's an area that I'm fascinated by, and I think we're only still at the cusp of what's coming on these issues. And I think what you need to bear in mind is that this technology is all about, as the internet enabled an exchange of information, these systems can not always, they don't always do, but they can enable an exchange of value in a digital format. So I think that's why they're so exciting. I find them very exciting, although at their heart, actually, they can be quite dull in terms of what's in the middle of these. I had somebody once said, "Oh, well, blockchain, that's just a glorified spreadsheet," and I think that's probably right. That's the kind of the power of blockchain, that it is a glorified spreadsheet, because it's a spreadsheet in which multiple parties can have access to at the same time. So that's the kind of the place I'm coming from. It's a new. So we first got involved in late 2016, 2017. There's been a peak. There's been a hype journey. Probably peak hype in 2018 as Bitcoin first spiked. But I think what we're seeing behind the scenes over the last 18 months to 2 years is a real progression in terms of putting in place, in certain sectors, certain areas, ecosystems that enable this technology. And it's very much emerging technology. It's evolving all the time to take place. So in that context, in terms of arbitration in the space, and I have probably a slightly unusual background in that I'm not by background a technology lawyer. I'm by background a disputes lawyer, mostly arbitration, but I kind of fell into this area, so I can see where the two might meet. It's mostly at the discussion stage at the minute, because people are putting into, those that are thinking about it, and there's a lot of technology out there where nobody has been thinking about many of the legal aspects, certainly not dispute resolution. There is a school of thought that you don't need a dispute resolution here because it's all in the code. The code is law, to paraphrase, and nothing will ever go wrong. I mean, and I think we just know that that's not how the world operates. So what we're doing at the minute is a lot of discussion with clients and industry bodies in terms of when they're putting in place ecosystems or platforms, and then how do you embed within that, or if you want to, should you look to embed within that a dispute resolution clause, an arbitration clause, and how do you do that? And then I think the fundamental issue to bear in mind here is that you're going to have disputes kind of, and this is a very loose way of describing it, within the code. Has something gone wrong with the code? And you're going to have disputes outside of the code. Does the code not meet the parties' expectations? And the latter are, frankly, no different in principle than any other dispute. It's just expressed in a different format. Where you do have some issues is how then do you build on your traditional protections and routes on top of that. So yeah, that's where it is. It's still very much at the discussion stage. We've been involved in a few disputes arising out of digital assets, but none of them are anywhere near having an arbitration agreement in place. It's a slightly wild west, frankly, in terms of some of those areas. But it's no surprise the regulators, whether that's the financial regulators, the data regulators, that they're catching up with this new technology. So it's no surprise that the kind of the legal world and the arbitration world should be in the same position, I think. And what we've always said when asked on the regulation front is, and Brandon, this is touching upon something you said, how do you keep up with technology that's always changing? Try not to regulate the technology, regulate the use of the technology. And I think in the arbitration context, it doesn't quite work, but the approach should be, I think, well, how do you apply existing principles in a slightly new landscape?
Yeah. And what can can you list pros and potentially cons of using arbitration in this particular field?
Yeah, this will be fairly short because it's such a new field. The difficulty is getting an arbitration agreement in place. In the whole idea of these systems is that you allow multiple. The value of a decentralized network is that it's decentralized. You have multiple parties involved in it. If you're looking at an arrangement between a few parties, you probably don't need to use this technology. It would be a waste of time and effort often, and often it is. So it's really when you're trying to do things at scale with lots of different parties, and then that won't surprise anyone in the arbitration sense. How do you get a working arbitration agreement in place that's valid and binding on people? So that's the one of the cons. I mean, there are also difficulties. Let's say you do end up with a dispute. How do you and you've got an asset or an arrangement that's essentially recorded in code. How do you decode the code and get that into a legal framework? But that's no different for arbitration than it is for court discussion. And the answer essentially is the use of good experts. And the pros are, and the obvious one is, these systems are inherently cross-border, international matters. You often won't know where your counterparty or parties are. Just trying to identify where a transaction takes place is an interesting debate. You could have hours discussing that. So it's inherently cross-border and international, and just the flexibility you have with an arbitration agreement, the comfort that you can have that you're not going to end up, well, you shouldn't end up in some obscure jurisdiction that you don't want to end up in, and the enforceability, the usual benefits of arbitration. So again, it's a good, they're limited answers to that question, but it's a good way of highlighting, I think, that this is not, it's not something completely new. It's just applying the existing procedures and principles in a new landscape.
Yeah, I can see that. And what are the disclosure and privilege concerns in decentralized networks?
Yeah. So start from the premise that we're essentially talking about a distributed ledger technology. What that means is everybody has access to the same ledger at the same time, the same glorified spreadsheet. So everybody has access to that at the same time. And of course, there are permission protocols in terms of what goes on to that chain of information, what goes on to that ledger. But essentially, the value is in parties having access to that. So in terms of documents or data, whose document or whose data is it? And who has care, custody, and control of the documents? And that's both as a matter of practice and as a matter of kind of legal analysis. Whose are they? That can be very. It's completely. It can be managed. It can be resolved, but in the systems in place today, it hasn't been thought about often. So it's a slightly grey area there, and the same issues. I think when you're looking at giving legal advice, it's the same premise in a multi-party access system. Whose document is it? Who created it? Who owns it? Who has the right to use it? Alongside then all of the extra questions in terms of the validity of the document. How do you know it's not been tampered with? How do you know the record? I mean, those issues should be resolved in a blockchain scenario, at least, because you should have a ledger of what happened when. But the tricky elements are, well, okay, but whose document is it? Who has rights and control and care and custody over that document? Those are the core concerns, and we haven't really had too many examples of that at the back end, at the dispute end. It's more when we're looking at putting together arrangements within the markets. How would you go about building a system that gives you some protection, some guidance in that perspective?
Yeah. And Lee, for the ones that are not very used with this topic, as it's all very new, as you just said, how can we preserve data security in blockchain-based arrangements?
I saw that question in the paper, and it's like that's probably the toughest question in this field at the minute. And I'm going to start by giving a slight caveat. I'm not a data protection specialist. I have very clever colleagues who I pick up the phone to when we're involved in something and say, right, how do we make this GDPR compliant or something? So there, I'm going to start with that. However, and it is a very challenging environment, especially for personal data. There's no way around that. However, what the technology exists for this, you have a link, you have a distinction between, so start with a blockchain system, which is essentially a chain of information, a chain of records of transactions. So you have that chain of data. What you can do is take the sensitive data, the underlying data, and take it off chain. So you have I won't go into the technology too much, one, because it will take too long, and two, because it's very complicated, and I'm not sure I always understand it. But you essentially take off the sensitive data into an off-chain environment, and you only have access to the outcome, if you like, of that data. So there are all sorts of low trust protocols, Byzantine fault tolerant protocols, in which you don't see the underlying subject matter, but you know that if this happens, the answer must be red or yellow. And all you need to put on the blockchain, on the public system, is the outcome, the red or the yellow, not what's underlying that. I'm grossly oversimplifying it, but that's, you've got to think about it in terms of different layers. If people are interested, I just discovered this week, actually, on the website for the Web3 Foundation, which is a spin-off from Ethereum. It's essentially looking at reimagining the internet and having it much more in a much more decentralized manner, with individuals and companies having much more control over their data. If people are interested, I would encourage you to have a look at their website. They've got a very good, simplistic, and I mean that in a good sense, not in a bad sense, a good, simple kind of analysis of the stack of technology, and you can see the different layers and the different protocols. And essentially, you have a within them, you can. I think I'm oversimplifying this. You know, the best minds in cryptography are dealing with this, but you can essentially ring fence your data and only give access to the bits that a counterparty will need to have access to. So that's the bigger picture. The short picture, it's difficult, and that's often where we're involved in projects, and that can often be meeting data protection requirements can often be the stumbling block in getting something to work.
Yeah, thank you. You made a very, very clear explanation. So, moving to a different topic, if I may. In your opinion, Lee, what are the most interesting provisions contained in the digital dispute resolution rules that were published in April by the UK Jurisdiction Taskforce of LawTech UK?
Yeah, so these are a new set of arbitration rules specifically for digital assets and decentralized networks. They've been we didn't drive it at all, but we were involved in putting some input into the scheme there. And what it is essentially an attempt to write a set of rules that you could embed in a digital asset or a blockchain or similar transaction with use of smart contracts. They're written in, just to clarify, they're natural language. They're not coded. You don't need to be a coder to read these things. They're a fairly short form of rules, and they're good. I think the interesting things are the fact that there's just an engagement with this in terms of how the rules might apply. I said before, my view is don't regulate the technology, and equally don't focus too much on the technology, focus on the outcomes. But there are some interesting provisions in here. I'll just highlight two. The rules give the tribunal an express right to modify the the relevant digital asset. So the parties agree that if the outcome is that, you know, party X owns the token rather than party Y, the tribunal has the right, if the parties don't do it, to go in and modify the ownership record. I think that's very sensible. How that works in practice is yet to be seen, frankly. But that's an interesting piece. And then there's also, secondly, an optional anonymity clause. So the parties can remain anonymous if they wish to. That's again, it's an attempt to meet the technology, because anonymity is one of the issues, one of the benefits of these networks, sometimes in a positive sense. I'm not talking about the misuse of this technology, and absolutely it is misused in the dark web and what have you. But that's an interesting part of the rules. And I can see immediately any arbitration lawyer will see the challenges raised by that. I suspect that probably won't be used an awful lot. I suspect. I just see so many difficulties with that in terms of your counterparties. But those are two two detailed provisions of the rules. But I think more importantly, it's just, and I'm sure Sarah, I'm sure your institution is doing it. It's just the attempt to engage with this kind of new part of the economy.
Yeah, and a question that I have here personally, and in the practice, what do you believe that are the most common cases that would be very suitable to those rules?
So you can imagine what's holding back some of these sectors at the minute is that the Bitcoin-based blockchain, where it all started, and the Ethereum network are now being used for personal transactions and tokenized transactions around the world. The commercial uptake of these networks is embryonic and won't really take off until you create, in my view, ecosystems within markets. So they're slightly more private, slightly more permissioned. I use an analogy that the Bitcoin blockchain is like Hyde Park in London or Central Park in New York. And actually what we're talking about is creating private gardens for a group of residents, little lockdown gardens where only certain people can have access. And that's where that next step is necessary, I think, for the commercial. Here's our ecosystem. Here are the rules of using that ecosystem. And you can just, you could be trading commodities on a platform, for example, and you could easily link to those rules and say, right, well, if we have a dispute, and there are always disputes when you're trading commodities, here, regardless of the technology you use, click here to apply these rules. So that's the sort of sector, I think, it not linked to one sector, but it's within the ecosystems that would allow you to do that.
Yeah, nice. And how do you believe that, how has the pandemic affect the scenario of the role of arbitration in smart contracts and digital assets?
It's interesting that the pandemic, I think what it has done, obviously not just in the smart contract space, is it's accelerated the use of digital tools on an everyday basis. It's made people, if not more comfortable, then you have to use them. I was having a discussion last night with some colleagues who we were amazed at some of the more old school partners in our firm who 2 years ago would never have gone near a video call, and now it's part of their daily life. And I mean, that's a silly thing, but it's just an example of how if anybody doubted that we're in a digital economy before, I think that's no longer in question. So there's that bigger piece. I don't think there's anything more specific in the pandemic for smart contracts. I think actually what might drive use a lot more is the current supply chain crisis, where people don't know where their goods are, often know where they are or whose party is responsible for them, because it's just a bit of a mess. It's that sector where there are some obvious use cases for this technology, I think, and I think in the long run that will have more of an impact than the kind of COVID pandemic itself. It's the knock-on effect of that.
Yeah, and since we're dealing here with this very new field, what are, and this is a broad question, what are your expectations for the future in terms of dispute resolution?
Good question. I think what we've seen to date, lots of disputes, but they've been in a sector where, frankly, let's be frank, you're at the slightly dodgy end of the use of this technology, Wild West, unregulated sectors. And so if you have a dispute in that sector, you're not going to resolve it in a formal mechanism because it's something you're just not going to do it. So those haven't yet been part of a formal dispute resolution process. I think over the next couple of years, we will see disputes arising out of unintended consequences, people not quite fully understanding what they've gotten into or not quite fully understanding how the technology works. So there will be some fairly traditional looking disputes, I suspect, arising out of, oh, well, whilst it did this, we didn't expect, it did X, we expected Y, what's gone wrong? But I'm a believer in this technology, maybe not in its current guise, but I think sooner rather than at some point, I wouldn't say sooner rather than later, it will be how parties transact with one another on digital platforms and networks, and there will be various staging posts to get to that, I suspect, but then that will just be how it is, and then you'll end up with the same sort of disputes, but in a different context. But that's a few years away, I suspect.
Yeah. Well, I believe that I will now move to the questions from the audience. I do encourage everyone to make a good use of this opportunity that we have here today with Lee, as he is well recognized, especially specialist, a leader in this field. So the first question that I have here is that, Lee, do you think that blockchain technology or advent of technology will impact the way arbitration is conducted procedurally?
Yeah, it's a good question. There are lots of blockchain arbitration initiatives out there. I'm not convinced by many of those in terms of, frankly, if you've got a dispute, your dispute might be that something's gone wrong with the digital environment you're in. Why on earth would you want to have the arbitration resolved in that environment where you say something's gone wrong? I think where the real benefits will be to say, I mean, blockchain, it gives you a ledger of transactions. It gives you the history of the relationship. So there's your obvious starting point for disclosure. So could you agree between your parties that the scope of disclosure between the parties is whatever's on the chain and that's it? And I think you could, but of course that only gets you so far if your real dispute is that the transaction didn't meet your expectations. Your expectations are not on the blockchain, they're outside of it. So it does have a role to play, but it only, I think, and I'm very happy to be proved wrong, but only a limited role, only a part role, I think, in the process. I think the idea that you can have some kind of eBay dispute resolution mechanism, and there is that dispute resolution mechanism on the eBay platform. I'm not being dismissive, it's very good. But the idea that you can have something that scales, I very happy to be proved wrong, but I can't quite envisage what that would look like.
Yeah. Lee, I have for you a couple of questions that I made for Brandon. The first one is about your experience with the parties' willingness to engage with cybersecurity issues right now, before and after the pandemic hit, but how are they dealing with that in your experience?
I think now there has been a change. I think now it's not even, whereas before it was kind of seen as something that, well, do we have to do this? Can't we? But now I think there's no question that certainly amongst large commercial law firms involved, you do engage. There's no question, and we each have. We're not allowed. We have our own internal rules and protocols as do other firms. So it's more a case of which one are you going to use and how you're going to put it in place, rather than is there a question of engagement. And look, there's an element of self-preservation in that from the law firms.
Yeah. And do you know any cyber attacks in the legal sphere? that you were aware about in your experience?
No, Brandon referenced a couple of attacks in the barrister space. I'm not aware of any specific attack on any matters. I'm just thinking through. No. I mean, the biggest problem at the minute is when you have someone's Wi-Fi drop off, and that disrupts the whole proceedings. Or the funniest thing I did see in a proceeding was counsel on the other side who somehow every time he wanted to make a staged laugh because he was outraged at some of our submissions, would somehow his microphone would unmute miraculously just as he was doing his staged laugh. But I don't think that was a technical glitch. So no, sorry, I'm being flippant, but I haven't had any experience or knowledge of any actual attacks on proceedings.
Yeah. And Lee, if we, I heard this question the other day, and if we have a client that is not very engaged with cybersecurity issues, what can we say to him?
Good question. I mean, there are two layers to that. I would probably say, well, one, you might not be engaged, but I have to be engaged. And so this is the kind of the rules of the game. And secondly, I think within that, but all you can do in any context is set out the risks to your client in terms of if he doesn't proceed in that way, these are the risks of doing it. And leaving aside our professional obligations, you then have to just make it clear to the client what the risks are, and ultimately it's their judgment, again, leaving aside our own obligations.
Yeah. Very good. Let me see if we have any other questions. If you guys want to make a question, the time is now. No, I believe that's it. So thank you very much, Lee. I will now move to Sarah. Sarah, are you hear me just fine?
I can hear you.
Oh, good. So, Sarah, thank you so much for joining us this afternoon in Hong Kong, right?
That's right. It's the early evening in Hong Kong. It's my pleasure to be here.
Thank you. So, Sarah, how do you see that cybersecurity risk can materialize in arbitration?
Yeah, I think that arbitration is a process, and taking into account the participants in arbitration and how the process works, there are, I guess, infinite ways in which the process could be subject to cybersecurity risks. But taking inspiration from the ICCA-NYC CPR Protocol that Brandon introduced and chaired, which is an excellent document, and I commend to all people interested in this area, I would look at 4 broad areas or aspects of the arbitral proceedings in which cybersecurity risks can materialize. The first is with respect to information exchange, the second with respect to storage, the third with respect to travel, slightly less relevant in the last 2 years, but resuming relevance, and finally with respect to hearings. So I think, a lot of these are quite obvious, but with respect to information exchange, as Brandon has mentioned, there are, it's very common that arbitrations contain sensitive information, commercial information, as well as personal data. And that information is not publicly available. It's available within the arbitration proceedings, and it's guarded by various actors within the proceedings under confidentiality duties, which vary between participants and vary according to different procedural rules. But if that information became available, it would have some kind of value, usually negative value, and that is the leverage which the cyber criminals are relying upon. So with respect to that sensitive information, in arbitration, it's par for the course that information is exchanged electronically and typically by email. And therefore, all of the vulnerabilities that are relevant to electronic exchanges by email apply to arbitration. And when we're talking about arbitration, we have, let's say, a confined set of participants in an arbitration, and that makes up this a digitally interdependent group of people, or let's say a network. And when you're thinking about cybersecurity, you're always thinking about the weakest link.
So within that network, whoever has the weakest cybersecurity measures in place is going to set the standard, generally speaking, for the overall cybersecure health of that proceeding. So if you have, for example, in an arbitration proceeding, a tribunal member who is operating a free web-based email account, say a Gmail account, that is going to be a vulnerability for the whole network of that arbitration. Or if you have a legal representative who's traveling and who is connecting to a public connection which is not secure, then that is also going to be a vulnerability point for that arbitration network. And once those vulnerabilities are exposed by cyber criminals, you can have a range of problems. So you can have then all of those email accounts become targets for phishing email attacks. And I think, you know, we're all familiar with the very clumsy, conspicuous phishing emails that we've seen in the past. But nowadays, you have to be extremely careful because the phishing attacks are highly sophisticated. And especially when cyber criminals know what they're looking for or have a better understanding of the information that they have gained access to. And so I think that, you know, we've already said it's an evolving space, that's obvious. But the sophistication of phishing emails is really increasing. And I think people need to be constantly aware because, you know, if you're checking emails on your phone, you're in a rush, you're jumping out of a cab, what have you, it's not difficult to see how you can fall victim to some of these phishing attempts. Or you can have the distribution of malware, which of course has potentially very bad consequences for all involved. So that's one major risk area that materializes in arbitration just by nature of the communication method. Then I mentioned storage. So of course, in arbitrations, you have multiple participants and they are sharing information and storing information, not only their own information, but information that belongs to another person or another entity. And so again, you have the issue of the weakest link. How are all of the participants in the arbitration storing their information? How are they protecting it? And a number of issues come up in this respect, including whether or not parties are using passwords, whether or not parties are employing multi-factor authentication in order to access their networks, whether parties, and when I say parties, I mean broadly participants in the arbitration process, so also tribunals, also institutions, whether or not they are employing encryption technologies with respect to perhaps individual files or hard disks or cloud storage. So these are all issues to do with the safe storage of information, which obviously is highly relevant in arbitration. I mentioned travel. Of course, we've traveled a lot less over the last 2 years, but many jurisdictions are resuming travel in a pre-pandemic fashion. And travel has its own set of cybersecurity risks, and they're perhaps a bit more ordinary and easy to avoid or easy to control. And a lot of these risks overlap, but they include the fact that when you're traveling, you're more likely to log on to an unsecure public network and to do some work through an unsecure public network. You increase the risk of just simply losing your device. And if it's not properly locked, if the data is not encrypted, then of course that data is then vulnerable. There's also unwanted access to data at border crossings. And just the mere fact that often when you're traveling, you're working in a public setting, so you may not be guarding the confidentiality of the information as best you would in a private setting. Perhaps you're on the phone, perhaps your screen is visible, perhaps your password is going to be exposed, things like that. And then we come to hearings, and I think there's a lot of overlap with the things I've already mentioned with respect to information exchange, as well as the storage of information and travel. But with respect to hearings, in my experience, when we all had to pivot to virtual hearings, there was a lot of initial concern around cybersecurity. And I think that was because a lot of us had not dealt with cloud-based platforms for video conferencing a lot in the past. There had been a lot of IP-based connections in terms of video conferencing, but of an old-fashioned system now, but still available and still highly secure. So we were all a bit less familiar with cloud-based systems like Zoom, and there were incidents of people entering hearings and they were not authorized, they were not invited, they perhaps inadvertently entered a meeting room, but there was also concern around Zoom bombers, so people hacking into hearings. And I think that we're generally past those concerns. Most concerns that we see here at HKIAC have to do with whether or not witnesses are in a proper setting and the integrity of their testimony is safeguarded, rather than cybersecurity concerns. And I think that those concerns have moved to the background for two reasons. I think it's because virtual service hearing providers have established pretty clear and secure layering of security measures to ensure that hearings are secure. For example, passwords, and hearing managers that operate according to authorized lists of attendees. And that seems to provide the necessary level of security for hearings, certainly in our experience. And secondly, those cloud-based platforms like Zoom have responded to some of those concerns and have offered pretty shortly after they became extremely popular, waiting rooms as well as end-to-end encryption. And I think that has helped a lot. But that gives you just a snapshot of some of the ways in which arbitration can be, well, some of the risk areas in arbitration proceedings.
Yeah, that's all very interesting. And Sarah, how to minimize those risks?
Oh, that's the golden question, isn't it? So I think I would say, I would refer everyone to the ICCA-NYC CPR report. And I think that takes a really very helpful two-stage approach. And the first stage is, first of all, to do an audit of your own digital architecture. And that applies to all participants in arbitration. So whether you are a law firm, whether you're barristers' chambers, you're a sole practitioner, you're an institution, you're an arbitrator, practicing out of a law firm or any other kind of entity, you need to first of all check to see that the architecture that you have in place with respect to cybersecurity is of a standard that is reasonable. And reasonable, of course, is a broad term, and there are many different ways to interpret it. But the protocol gives us a quantified starting point, if I can say that. I think we can think about it a little bit like the IBA guidelines with respect to conflicts of interest in arbitration. It's impossible to completely define all of the scenarios that one must think about and to define the standards that people must meet, but it is at least the beginning of some kind of quantification. And so that is helpful. And I think, apart from it being soft or perhaps becoming soft law in the future, at least it provides guidance that people can look to and think about and have some kind of measure on their own activity. So that's the first step, checking your own architecture. And the protocol is accompanied by 6 schedules, and the Schedule A is the schedule that talks about your own architecture, and it is very useful, but some of the examples that it lists are, first of all, keep abreast of cybersecurity developments. Now, of course, if you're in a law firm, you have an IT department that's going to do that. If you're a sole practitioner, maybe that's something that you need to become aware of or educate yourself on, or you need to contract that out to specialists. But that's, first of all, very important. Secondly, think about the way in which you manage sensitive data. So how do you store it? Do you ring fence it so that only certain people can access it? And how do you protect it? Do you protect it in a way that's different from other data? Think about your access controls. How protected is your data? Are you behind, or do you use complex passwords? Are they updated on a regular basis? Do you use encryption? Do you use biodata to access networks or your devices, like facial recognition or fingerprints, retinal scans? And then I think also what is very important is to make sure that whatever systems you have in place, that the software updates and the patches that are issued by different technology providers are implemented immediately. Because this is really where we see the cat and mouse game played out in this sphere, where you have, cyber criminals working to always identify the next vulnerability. And then you also have cyber professionals working to identify the next vulnerability, but in order to design protection. And it's always a bit of it's a race. And so the faster that you can implement these protections in your own your own cybersecurity digital landscape, the better. So that's the first prong. And then the second prong is looking at the case-specific requirements of the arbitration in front of you. And there you need to consider a range of factors in terms of whether or not you are dealing with highly sensitive data, whether or not, procedurally speaking, the arbitration can bear certain cybersecurity measures, and if so, what are they? Are all of those measures available to all of the parties? Are there any due process concerns? Again, I think it's Schedule C looks at some of those factors, Schedule B looks at some of those factors, and then Schedule C to the protocol suggests some sample measures that you can adopt in different arbitrations. I think the takeaway point is that there is a wealth of information out there, and it's simply a matter of accessing that information and looking and thinking about what one needs to, first of all, improve your own digital systems, and secondly, what would meet the needs of a particular case. I would also commend to listeners the IBA cybersecurity guidelines that were published in October 2018. Those were written for lawyers, and they provide some really helpful information with respect to the risks involved in cybersecurity and what you can do to mitigate those risks.
Well, I believe that the natural following question here is the one that we have from the audience, and I'll read here. What measures are being adopted by the Hong Kong International Arbitration Chamber and other arbitration institutions to protect the proceedings from cybersecurity attacks, or any other measures that can be applied? And here I'm adding something to the question. Any other measures that can be applied to ensure cybersecurity in international arbitration?
Yeah, so I think institutions have an important part to play in this area. From HKIAC's perspective, we've done our internal upgrade in terms of cybersecurity. We did that back in 2018. What we did was we put in place server disk encryption. That means that all of our hard disks and all of our desktops and all of our laptops are encrypted. So that's an important protection of the data that's kept on those devices. We have multi-factor authentication to our document management system, so that enables us to work securely, remotely from the office. We have, of course, all of the usual antivirus and malware protection, and our IT specialists are downloading patches and making sure software updates are put in place immediately. I mean, that's just part of the IT team's work. And we also we transmit files to arbitral tribunals, typically behind a password-protected secure portal. So that's what we've done, and you have to keep checking in to make sure that you're up to date with whatever the latest risk is. And I would note that it was just yesterday that Microsoft issued an urgent software update call with respect to its very popular email server, Microsoft Exchange. So that's something that we've done, but this is something that is in response to quite a few attacks that have been happening just recently, not just to arbitral institutions. Any corporation is vulnerable. And then I think the really important role that institutions play is to offer relevant tools and also procedural frameworks to parties and tribunals. And when it comes to tools, I'm very proud actually to say that we just launched our what we call HKIAC Case Connect, and this is a secured online case management platform, and we provide it to parties and tribunals in our case free of charge. And so what this means is that you have a secure online platform to which you can upload all documents in a case. It centralizes all case information, including all contact details of the parties in the tribunal. It also provides a procedural calendar which traces the timelines, the deadlines that are coming up and important dates in the case. So it's really a home for the whole arbitration, a digital home for the arbitration. And it's banking grade encryption. And so that is the highest standard of encryption that is available privately, that is non-government standard. And so that is secure, and that is available in our cases from now on. And so I think that that's a really important tool. And I think, parties that are involved in cases with highly sensitive data will be very attracted to that tool. So that's one thing that we as an institution can provide. And then I want to talk again a little bit about, I don't want to repeat what I've already said, but when it comes to virtual hearing services, I think it's important for the service providers to provide the different layers of security for parties and tribunals in their hearings. And at HKIAC, we pivoted to virtual hearings very early on because, of course, the pandemic, it was very early on in Asia, and it came to Hong Kong late January, February 2020, and we had to pivot literally within a week to virtual hearings. So we did that, and we've done over 160 virtual hearings now over the last 2 years, and we haven't had any cybersecurity incidents that we are aware of. And so I think that that's good. That's a good record. So yeah, that's what we are doing. The other, just to conclude on this point, as I mentioned, a procedural framework, and we are seeing institutions start to embed in their rules encouragement or requirements of tribunals to take into account cybersecurity measures. And the latest version of our rules is our 2018 administered arbitration rules. And in those rules, what we did was we foresaw that people or parties would be using secured online repositories, that was a direction that a lot of tribunals and parties would be heading. And so in our rules, it is expressly recognized that if you upload a document to such a secure online platform that has been agreed upon by the parties, that will constitute notification of that communication in the arbitration. So that's in our rules. Our rules also exhort tribunals to take into account the use of technology when they're designing the process, specifically to save time or to avoid unnecessary delay and expense. But it also, I think, turns tribunals' minds to cybersecurity measures and what needs to be put in place, or at least discussed with the parties early on. So yes, that's what I think. That's where I think institutions can really contribute.
Yeah, it's very good to hear about all of these measures, and especially the ones that are implemented by the Hong Kong International Arbitration Center. So Sarah, in your experience, how are the parties, the tribunals and the arbitral institutions adopting those cybersecurity practices?
Yeah, in my experience, it's quite divergent. We still see plenty of cases where cybersecurity is not raised by the parties or the tribunal. And I think that there are cases that exist where everybody who is involved, and when I mean the parties particularly, are comfortable with with no specific cybersecurity measures beyond the normal confidentiality requirements that the parties and the tribunals are under according to the applicable law, procedural law, and the rules. So we certainly see that, and of course those are in the cases where there's much less at stake, where perhaps the information is not so valuable for or not so harmful if it were to be made public. And the stakes are not high, and maybe we're talking more about smaller domestic cases, perhaps. But there are certainly many arbitrations where that is not the case. And we see more and more in our cases, and particularly this year, we've seen more cases where the parties and the tribunals have raised cybersecurity specifically from the outset of the case and have put into place in their procedural orders measures with respect to cybersecurity. And one of the most common measures we've seen parties put in their orders is that the parties will take reasonable security measures when they are transmitting information in the arbitration. And that if there are documents or if there is information that requires heightened security measures, then the parties will confer to decide what appropriate measures will be taken. So that is what we have seen, but as I said, it's quite a mix, and it really depends on the case and on the participants in the arbitration. I would say also that another, I think, influence that institutions can have is in this space by making available to tribunals language that can be included in procedural orders. At HKIAC, we have a tribunal secretary service within the institution, so we have tribunal secretaries assisting different tribunals, and it has been the situation that the language has come from the institution to the tribunal, and then it's put to the parties, and everyone has then discussed and landed on what they are comfortable with or what they want for the case. And so again, I think that that's a contribution that institutions can make. We obviously have an excellent vantage point over hundreds of cases, hundreds of different procedural orders and language. So, you know, the benefit, one case can benefit from perhaps the experience in another case, and we are the participant that can share that information, obviously in a confidential way.
Yeah. And Sarah, a question that I have already made to Brendan and Lee. But from your perspective, do you believe that the pandemic has affected the perceptions that the arbitration users have on the adoption of cybersecurity measures?
I think it's yes and no. I think yes, in that with the pandemic, everyone moved online, and so I think that, you know, the use of secure connections was important. But at the same time, I think that cybersecurity was an issue before the pandemic, and the issues are somewhat separate. But I think that where the two link mainly are in the fact that, like I said, we're all online, and so virtual hearings have all gone online, and we need to make sure that those connections are encrypted, protected, and effective. And then in the second way, I think, is because during the pandemic, many people were forced out of their offices and to work from home. And again, that raises questions around secure connections. Many people are working from their home connections, which, you know, are much more secure than obviously a public unsecured network. But then again, I think that in the shift to working from home, perhaps it wasn't cybersecurity that was foremost on people's minds, but it was rather about continuing to be functional and trying to set up as fast as possible with the least disruption as possible, essentially offices in their homes, so they could maintain their normal workflow, and amongst all of the challenges that were brought on by lockdowns, by homeschooling, by the fact that hearings straddled multiple time zones and more practical issues like that. And I think that cybersecurity was perhaps secondary to that. But then once people got into the swing of their work from home lives, then cybersecurity was probably pretty quick to catch up as a key concern, especially not necessarily cybersecurity in and of itself, but more information security if you're dealing with lots of documents in your home environment, as opposed to your more secure office environment.
Yeah. And finally, Sarah, considering cybersecurity concerns, what is your opinion on the use of technology when selecting arbitrators?
Yeah, it's the last 2 years have changed things. As has already been said, it's obviously absolutely essential that arbitrators now are technically literate and can work across multiple different cloud platforms when it comes to running virtual hearings. But I think it's even more than that. It's not just being able to, function on Zoom, but it's about designing hearings and knowing how to run a case online and how to design it in the sense of, whereas you can sit for 8 hours in an in-person hearing, I think it's generally accepted that that's not really effective when it comes to virtual hearings, and there's a lot of virtual fatigue that sets in, and so you need to design shorter hearings. So I think that that's really important. And I think with respect to cybersecurity specifically, I think the days where an arbitrator can comfortably participate in arbitrations using a free web-based email account such as Gmail are generally over. Perhaps not for all cases, but for most. And I think that from an institutional perspective, if we are looking to appoint someone and we know that someone is only using such an account, we would hesitate to make the appointment, or we would speak to that person and raise our concerns. I think that that is also something that is well done by an institution, because sometimes parties may feel reluctant to raise a concern of that nature. I don't think they need to. I think that they're well within their rights to do so, and they should. But we as an institution would raise that, or we would look to appoint someone else. I think also because of the virtual setting that we're all operating across these days, connectivity is absolutely key. You can't have a hearing where the presiding arbitrator is dropping off all the time. That's way too tiresome for everybody. So, people need to invest in their digital technology. They need to upgrade if necessary, because that does count. And we've had situations where we were to appoint an emergency arbitrator, and the person who we would have liked to have appointed in this case let us know that he was in lockdown and he was not able to get to a place where he could ensure connectivity. So we simply weren't able to appoint him, and he would have been our first choice for other reasons in the case. So that's very important. And then I would say the final factor that is perhaps ancillary to all of this, but connected because of the virtual hearing nature of our work these days, is time zone compatibility. So when it comes to appointing arbitrators, in the past you would think about where someone lives and what travel would be required for them to go to a hearing and things like that. But now what we're thinking about is, what is the time zone compatibility between the counsel, the parties, and the co-arbitrators and the presiding arbitrator? And I think that at the beginning of the pandemic, people were quite open to working very late hours, sitting in hearings through the night and so forth. But I think that people have started to tire of that, because the pandemic's not going away, and it's not perhaps not a long-term sustainable way of doing things. I've seen in cases where recently we were mandated to appoint the presiding arbitrator, and the co-arbitrators were adamant. This was an Asian time zone case. The co-arbitrators were adamant that the presiding arbitrator should be someone who's based within an Asian time zone themselves, or willing to work within an Asian time zone friendly space. And so that has just added another angle to thinking about who is the best fit for a case.
Yeah, very good. And Sarah, there's a question from the audience that I made for Lee, but I believe that would be good to hear your perspective as well. Do you think that the blockchain technology, or advent of technology in general, will impact the way the arbitration is conducted procedurally?
I think so. I think it depends on the dispute resolution mechanism that the parties have agreed. We have seen disputes arising out of crypto activity, if I can say that. At HKIAC, we've seen about 6, and those involve disputes with respect to the platform, identifying which is the correct platform. And I'm cognizant that maybe I'm not using the correct term, so forgive me, Lee, if I'm not. But also another initiative that's happening in Hong Kong is a separate organization, a separate arbitration or dispute resolution organization, which is looking to set up or has set up a system whereby parties can agree their contracts and within the same system have in place an entirely online dispute resolution mechanism. And that the name of that organization is EBRAM. And so that's received a lot of backing from the Hong Kong government, a lot of funding. So I can't speak expertly on it, but that's something that is being looked at in Hong Kong. And I think, yeah, this space is one that's new with respect to dispute resolution. And we shall see.
Yeah, very good. There is a final comment that we have here from the audience. Maybe you can comment on that. It says here that in cybersecurity arbitration, there is a need for experts to give evidence. Arbitrators in cybersecurity matters should be having high technical knowledge. Ground scenario in HKIAC. Thanks. My question was the tech competence of panel in dealing with complex cybersecurity matters.
Absolutely. I mean, if you have a case involving complex cybersecurity matters, if it's the institution that is appointing, you will be needing to be appointing someone who has expertise in that area. So, yeah, that's absolutely relevant.
Yeah, it really is. So, Sarah, I guess I've made all the questions from the audience, and I must say that was fantastic. Thank you so much. Brandon and Lee, they were fantastic as well. Thank you all for being so clear with us. I feel very lucky to be here today with you. Things that we only have 2 minutes left. We have used basically all the time that we had today. I wish we could do this in person. So thank you all, guys. Let's keep connected here at the arbitration channel for the next panels. And the link to the next panels are here on the video description. Okay, so let's stay here. Thank you all. It was fantastic. Thank you.